Welcome to Behind the Case podcast, a podcast that focuses on navigating the challenges our clients face with divorce and family law in Dallas, Fort Worth, Texas. Behind the Case is brought to you by the Turner Monahan legal team. With over 70 years of collective experience in divorce and family law. Together, Tyler Monahan, Keaton Monahan, Tina Campbell, and the Turner Monahan team will discuss real-life cases, answer questions, and explore family law areas from divorce to child custody. Our goal is to clarify scenarios and demystify legal jargon, making the process less daunting and reminding you that you're not alone. So sit back and let's discuss what happens behind the case.
Heather, you mentioned at the beginning, high net worth cases are typically going to have more discovery. What is discovery?
So discovery is a formal process of asking the other side questions and asking for specific documents, like regular questions that we would ask for production, asking for their witness list, asking for their financial information in a formal process and in a formal way that the other side is required to answer those requests within a certain time period. And so and you can ask if it's a highly contested divorce, there's interrogatories and admissions, and interrogatories are questions that you would ask the other side, and admissions are questions that you're asking them to admit or deny to. Discovery is a very useful tool in that, especially if it's highly contested and you do know that this case is going to end up in front of the judge, and we are going to need this information to use it in evidence or
for mediation.
And for mediation. For mediation, it's a very good tool for mediation because once they know what's out there and what you have, parties are more likely to agree and reach agreements at mediation rather than trying to take this in front of a judge and let the judge make a decision about their entire life, after they've only heard their information for a few hours. So it is a very good tool for negotiations and for mediations as well.
And discovery, a lot of attorneys think discovery is used only to locate stuff. Discovery is a great tool to limit evidence as well. Because if you request discovery, and whether it's through production inspection, which is asking for documents, or interrogatories, which is asking for sworn to statements, or admissions, which is saying, as Heather said, admit or deny, if there's information that's not provided to you in the formal discovery request, the other side can't use it. It doesn't matter what they want to do. It doesn't matter if they show up at the last minute with all this information they want to use. If they did not disclose it, they can't use it. And
that includes calling a witness that they did not disclose.
That's correct. And the reason why is courts want all the information out there and known by the parties so that they can have the most efficient trial as possible. They don't want things sprung on the other party in the middle of court, because then that disrupts the entirety of the court. And really, judges really would love for all parties to go reach agreements. That's why they have mediation now, and I would too. And the reason why I say that, even though we're taking money out of our own pocket, you would rather have a decision made by the two parties than a judge in most cases. Two people are probably going to make good decisions for their children, and they're probably going to make just and right decisions on how they're going to divide assets. Now, you have the outliers that occur all the time, right? That they just can't get an agreement done, and that's understandable. Maybe there's no way to have a meeting of the minds, or maybe one side or the other is not providing the information that's needed. Yes, you're going to have to go to court, but attempting to get agreements through mediation by utilizing discovery tools and other things of that nature is really the route to go, and that's the mindset that a client should be in to try to get their case finished. And if not, then we go to trial down the road.
I know you mentioning mediation a lot. So kind of, can you explain more about what mediation is? What does it look like? And because I know you watch movies, one spouse on each side of the table, a judge in the middle, and your attorney is and you're yelling at each other. And so I think that always scares people with the idea of mediation. But what does that mediation actually look like?
Well, it doesn't look like that in Texas, especially in our area with family law. Family law, we're going to be in two different conference rooms, first of all. Each party will be in a conference room with their attorney, or if the party wants to represent themselves. Everyone's going to be in different rooms. And the mediator is a neutral third party. Oftentimes, it's a retired judge, but it's definitely, in our cases, going to be a family law attorney. It may be a retired judge, but there's going to be someone who's knowledgeable about the family code, knowledgeable about your particular court that your case is in, so that they can help you as the client make a decision based on the facts of your case, the evidence your attorney would present to the judge if it were to go to trial, and what that judge's likely ruling would be. Clients want things here in Texas that may not be provided in the family code. Texas is a little bit behind on our child support laws and our possession and access, custody, visitation laws. So statutorily, Texas does not have a 50-50 possession and access schedule. So a lot of the judges are slow to come around on granting a 50-50 possession and access schedule. We have some that are, but especially in the outlying counties, they're really not going to look at doing that. They're going to follow what the family code provides for a possession and access schedule.
What does mediation allow you to do?
But mediation allows you to make decisions outside the box, outside what the judge would normally grant. And you can be very creative in mediation. You can come up with your own possession schedule that works for your family. Child support, which is also governed by the family code, is, if there's a certain percentage for however many children you have. However, you can also reach agreements in mediation regarding child support amounts, or sometimes not even paying any child support, especially if you've agreed to a 50-50 possession and access schedule and the parties are making about the same. It's a really good tool to reach agreements that are creative, and even property settlements that can work best for your family. If you were supposed to take this to the judge and let the judge split everything down the middle and put a rubber stamp on your possession access and your child support orders, in mediation, you get to be involved in making the decisions regarding your family. And that is probably my favorite part of family law, because parties are happier after they have made those decisions themselves and participated in those decisions, and they feel more confident in their final orders after they've participated in mediation. And
they know them much better, meaning they understand the terms much better than when a judge makes a decision.
Correct. And if you reach an agreement at mediation, it's binding and irrevocable, meaning that 2 days later, the other side can't go talk to their mom or dad or cousin and say, well, you should have asked for this and that and had this different result, and why didn't you just take it to the judge? And it's binding and irrevocable. Nobody can change their mind. I always say there's no buyer's remorse after mediation. So, you want to make sure you're in agreement to it, for sure, but you also can feel confident that it cannot be changed. Whatever agreement you make at mediation will be turned into a final decree of divorce or custody order that will be presented to the judge.
And at mediation, a major factor about mediation is you cannot discuss any of the negotiations that occurred at mediation. You can't bring that up in court. You cannot subpoena the mediator. You can't say that we discussed this and I should have gotten that and we should have done this and they agreed to this, he said this, she said that. You can't bring any of those things up. They've done that on purpose. The Family Code legislature did a good job on putting in the terms of how mediation works. And in mediation, nobody's going to force you to sign a document. You're going to have all of the terms and all the decision makers there ready to sign off if you reach an agreement. And our clients are going to understand what they're signing. And if they don't want to sign it, they're not going to sign the document. We don't force our clients to sign anything. This is not attempting to get people to enter into agreements that they don't want to agree to. It's a way for two parties to be able to come together, attempt to cut down on the angst, because there's a lot of anxiety going to final trial and continuing to go to court than there are going and sitting in a room with your attorney to try to get an agreement. It cuts down on expenses. It cuts down on the longevity, meaning the period of time for actually having to deal with the divorce and getting it finalized on the terms that the two parties agreed to.
Who's allowed to be in that room with you? Are you allowed to bring your mom with you?
That's a great question.
Yes.
No. unless the other side agrees that you can bring a third party, it is the attorney, representative, and the client, a mediator, and then the other side is their client and the opposing counsel and the mediator who goes back and forth. That's all. I always advise that nobody else comes to mediation because this is your mediation. It's not anybody else's. We all have, I love the Google attorneys. I love the Monday morning quarterback attorneys who they have somehow gone to law school overnight and they have been practicing for 50 years and they've also been a judge somehow, but they really have no idea. It's really a time for the parties to reflect on where things are and have the information that's available to them to try to come together and make an agreement, because it's about the parties and their children and their assets and potentially debts. It's not about the outlying factors who are contributing possibly to where those parties are. So I always like to advise that they don't bring anybody. What about you, Heather?
Same, always. I have had parties agree to allow someone else be in the other room with the other party to help facilitate it moving forward for all reasons. The other party's too emotional, or they're going to be helpful, is I guess I wouldn't say, but because you don't want to hinder the process, but if it's going to be helpful, then we allow it to move.
It's on a case-by-case basis.
Exactly, yeah.
And so, jumping back into high net worth, merging that with mediation, how long does a mediation in a high net worth divorce take?
Let's take a quick pause here. If you or someone you know is navigating divorce or family law matters in the Dallas-Fort Worth area, reach out to Turner Monahan for a free legal consultation. Call us at 817-332-4477 or visit us at tumolaw.com. That's TUMOLAW.com for a free legal consultation. Now, let's get back to Behind the Case.
I have a mediation set right now that's going to be 2 days, 2 full day mediations, which probably the first day will go for 8 hours if we haven't finished. I've had mediations in a high net worth individual case where we finished the mediation and signed the documents at 4 a.m. and we had gone the entire day. Okay. Yeah. Everybody was tired, but everybody wanted to get it done. Everybody wanted to see it done, and we ended up getting it done. Now, does that mean every mediation is going to go that long? No, but numerous times they are 2 to 3 days long in mediations, especially if experts involved and multiple attorneys and things of that nature, to make sure we give the best chance available for them to be able to settle the case. Have you had any high net worth that have gone more than a day?
A day, but not as long as yours, but a day and a half for sure. And those are hard because you have to leave and come back. So those are hard. But yeah, and I've had some that have lasted after midnight that haven't had to go till 4 a.m.
Yes. I would not recommend that, but it has happened. Everybody signed off. Everybody's happy. So that's great.
So high net worth, you're dealing with so many things. It's no longer just like, custody that maybe is your main concern. So are you able to say you agree on these things and you're taking the rest to court, or it's all or nothing?
Sure, you can have partial mediated settlement agreements. You definitely can have that. A lot of times those are bifurcated into, we agreed on all the property stuff, but we couldn't agree on the kids stuff. Very seldom do you have a situation where we've agreed on all of the kids stuff except for this one thing. We're going to go to court. Everything else is done. It's generally, from my experience, it's in one box or the other. If you have a divorce that only has property, if you can't settle, you're generally going to court on the whole entire thing. But it really depends upon where people are and what they want to do. It is not one size fits all. That's for sure in those cases. Do you agree with that?
I agree 100%.
So, we have mediation, and ideally we all end in mediation. Like, we all agree, but we don't agree now. What does court look like, and how do we prepare for that, especially in high net worth?
Well, preparing for court in high net worth cases is, once you've gone to mediation, when we go to mediation, we are basically prepared to go to trial. That's you're there. You might learn a little more information that you did not know. That's another part about mediation. You may end up learning some information that you did not know otherwise, or that could have come up after the discovery period, because sometimes you serve discovery and you don't go to mediation for 2 or 3 months. But we are generally prepared completely to go to trial at the time we go to mediation. The only thing we may not have done is put together tons of binders and things of that nature, and what I call woodshedding, any of your witnesses and or experts that you may have. When I say woodshed, you're actually talking to them. Hey, what are you thinking about this, and what's your position? You know, I don't do a lot of talking to witnesses to attempt to convince them to say one thing or another. I'm just not that type of attorney. I never have been, but I would like to know their position on what they may or may not say. So once you get finished with mediation, you are then in the process. You probably already have your trial date, or you should. You're in the process at that point in time of getting everything together to go to trial. Your witness list, your exhibit list, your binders, you're shoring up any discovery, because you have to have all your discovery supplemented 30 days prior to trial. There are so many things that go into it, and that's really where the costs really start getting up there, because the time that you spend preparing for a trial, 30, 40, 50 hours you're preparing for trial. You know, so the way I put it is for every hour that you're in trial, I believe it's somewhere between 7 to 10 hours of preparation. That's just me, to make sure that I know what's going on. So if you're going to be in a full day trial, you're probably spending 50 to 70 hours preparing for it, with talking to people, getting witnesses ready, getting your documents ready, making sure the discovery is supplemented, things of that nature.
And it's not just you. You know, our paralegals are going to be doing a whole lot of work too. And in a high net worth trial, paralegal is going to come with us, because they've been the one that has been really organizing everything for us to prepare for trial and help us make our trial more efficient and go more smoothly. And that is going to also add another cost to the client as well.
Well, and generally also when you're getting ready to go to trial, you're in our firm, it's not going to be just one person. It's not going to be one attorney. You're probably going to have 2, if not 3 attorneys that are working on your case, just because we want to make sure that we have crossed all our T's, dotted all of our I's. And having one set of I's is great, but having 2 or 3 sets of I's along with your paralegal, hey, that's even better. So that way we try to be as prepared as we can. No way to predict the future. And I always get asked, somehow I've got my psychic license, but I really don't. I don't know what's going to happen. And that's another reason why we always talk about trying to get something done at mediation, because we just can't predict the future.
Yeah, that the judge's having a bad day.
Exactly.
That's right. They're humans. They are subjective. They are not just black and white. They're gray. So they're going to make subjective decisions. And so people have to be prepared for that.
One final thing, and I hear it coming up a lot, that the cost is going to be more. And I know we can't say, hey, your divorce is going to cost this much, but talk to us about your pricing model, because I know you don't price like other attorneys. So how does pricing work here when we're looking at costs?
Yeah, so we do what's called a fee for service model. That doesn't mean it's a flat fee, which we'll hear people say, oh, it's a flat fee. It's not a flat fee. It's a fee for service. So once we speak with an initial, potential new client and somebody retains, we know where we are with how we're going to start off on their case, whether it's a fresh start, meaning we're filing for divorce or filing an answer and moving forward, or whether we're getting in the case in the middle of it. We're going to ask questions about, what type of issues are there with the children, if they're children, what type of issues are there in regards to the assets, and are people hiding things, and is there a reconstitution? Is somebody going to ask for support? All of those different things, that goes into our pricing model on how we start the case. And then after that, once you get to the point to where we've either done temporary orders, or if we came in and it was, hey, we're coming in, we're going to get everything together, and we're going to go to mediation. If we don't settle, now we're looking at the next step here. There could be additional hearings. Well, there would be a fee for that additional hearing, depending upon what it is. There could be a fee now because they've served discovery or we've served discovery. There's a fee that we have for the discovery. And there could be a situation where, okay, tried mediation before, it didn't work. The judge said, sorry, now you get on discovery, you're going back to mediation. Then there's a fee for us to go back to mediation. And ultimately, there could be a fee for us to go all the way to trial, okay? And we generally, in most, I would say 95% of our cases, our fees include us speaking with clients over the phone, returning emails, receiving emails from opposing counsel, speaking with the court. Those are generally included in our fees, because we know, hey, look, this is the time we think we're going to have to spend on your case. So we do it as a fee for service rather than a quote unquote a flat fee. And each time you know what you're getting into, you're going to know, hey, I know that it's going to cost me X amount to start this divorce. And then I know now it's probably going to be X amount for discovery if it's served, and X amount to go to mediation. We can't predict, no attorney can, but it puts us on the same side of the table as our clients to say, hey, we're not here just to figure out how to run up your bill and spend your retainer as quickly as possible. Our goal is to try to get your case finished as quickly as possible and efficiently as possible if that's what the person's wanting to do.
Yeah, because you're not charging them every time they pick up the phone to call you or send you an email like some attorneys do.
No, we're not charging hourly, but we can track things from an hourly perspective, meaning when we go in to get ready for trial, we know what we've done because we've written down, we know we've talked to them on this day, and we know we've sent this many emails, we know we've spent this time getting pleadings together. So we're able to go in and create what's called our attorney's fee statement for us to be able to say, this is what we're going to argue for attorney's fees. And I think, and Heather, you've come from doing basically all hourly. Do you believe that utilizing this type of fee structure allows you to concentrate more on a daily basis on your cases rather than having to spend sometimes a full day or more just figuring out your billing?
Absolutely. Absolutely. I can tell you, I always billed hourly prior to joining this firm just about a year ago. And I can tell you that it takes a lot of time, of my time, my paralegal's time on hourly billing. Not only documenting it, but also putting it in, depending on what system each firm uses. It does take a lot of time. And when I say a lot of time, I mean hours upon hours of my week was spent on clerical things, I would call it, because I had to make sure I got my billing entered. And that is time that I can spend either with my family or on other clients. I mean, I wouldn't say I'm working less here than before, but I'm working better, more efficiently. My time is spent more on client work rather than billing client.
Yep.
All right, awesome. So if somebody's listening that's in the DFW area, maybe has a high net worth divorce or any divorce really, how can they contact you to have that consultation?
They can contact us by phone, which is, our phone is 817-332-4477, same number we've had for at least 15 years. And then our website, we have a lot of information on our website as well on tumolaw.com, TUMOLAW.com. And as I've said before, the best thing to do is pick up the phone. Here at our firm, 99.9% of the time, somebody's going to answer the phone, okay? And once that phone is answered, they're going to get you to the person that you need to speak to and that you need to, and or you want to meet with. We do consultations a lot over the phone, and then we have people who want to come in and do face-to-face. We have no issue. And we do not charge a fee for our initial consultations. That's just not the way that we work. It would be like walking into Walmart or walking into a grocery store and saying, we're going to charge you a fee just for walking in here today. We don't, quote unquote, provide advice when we're doing our consultations because you're not supposed to do that per the ethics rules. But we will attempt to give you as much insight as possible on how we could assist you in being your attorney. And then hopefully you decide to retain, and then your money is spent on us working for you rather than giving you just some random advice for you to go take and possibly use on your own.
Thank you for joining us on today's episode of Behind the Case. If this episode offered insight or helped clarify some aspect of divorce and family law, we encourage you to subscribe and share it with others who might benefit. For those in the DFW area that are in need of a legal consultation, you can reach us at tumolaw.com, that's TUMOLAW.com, or 817-332-4477 to schedule a free legal consultation. Remember, the journey through legal matters can be complex, but you don't have to navigate it alone. Until our next discussion, take care. Please note that the information provided in this podcast is for educational purposes only and is not intended as legal advice. Listening to this podcast or contacting our team does not constitute an attorney-client relationship. For advice on your specific situation, please consult with a licensed attorney in your area.